visas and work permits, common problems and practical solutions. From my experience of being a director of the Chamber, this is often a very popular and controversial area of concern amongst many of our members, particularly small and medium businesses. How to obtain visas and work permits and how to renew them with a minimum of inconvenience and difficulty. Our guest speaker this evening is Kun Nutarot Tangprasiti. I'm told it's 50-50, so that's not bad. She is a lawyer specialising in corporate and commercial law with a unique cross-jurisdictional understanding of foreign and Thai legal systems. She regularly assists international and domestic corporate clients on the laws governing companies and partnerships, company formation, and compliance with the regulations of the Ministry of Commerce. She handles a multitude of different legal formalities in connection with this work, including advising on Thai company law, investment promotion policies of the Board of Investment, as well as compliance with the Foreign Business Act and drafting shareholders and joint venture agreements. She also advises clients on related matters, including work permits and visas, land and property law, including conveyancing and lease agreements, due diligence on land purchase, applications for construction licenses, and operating permits and licenses in connection with property. And she also deals with registration of ownership, the transfer of property, title, and mortgage registration. Ladies and gentlemen, can I first of all ask you to please switch off or mute your mobile telephones so there's no interruption to our speaker's presentation. So the presentation will commence now, and then afterwards we'll have a session of question and answers. Can I ask you to give a nice warm welcome to our guest speaker, Kun Nutarot, this evening.
Thank you, Stephen, and thank you all of you for the warm welcome. Actually, my name is Natharos, to be correctly pronounced. But it's fine but for many foreigners pronounce in Nutarot maybe off the spelling, but it's fine anyway. I'm delighted to be here in order to share my experience on the foreign employment and the staff mobility. Well, I'm sure that all of you have many problems with the authority, Department of Employment, or the Immigration Office. And of course, I have many problems with them. And I would like to share the experience today with you. And of course, I'm sure that you may have some different problems facing from the experience of you. I would like you to share also at the end of my presentation. So I would like to start first about the updated legislations. Currently, there was the emergency decree, which was issued, emergency decree on the managing the work of foreigners, which was issued last year in order to replace two previous legislations. I would like to tell you that today I will just only focus on the working of general foreigners, not to focus on the, not to mention about the Mekong regional foreigners, because all of you are the general foreigners, so I will just mention about this. I would like to show you about the main revision of the, sorry, it's so small because so many details. So I would like to share you about the major revision between the previous legislation and the emergency decree. First of all, it's about the definition of work. Nowadays, under the emergency decree, stated that any person who would like to work in Thailand with or without the employer in Thailand will be subject to this emergency decree. So it means that they have to apply for the work permit. However, in practice, I had a chance to discuss with the officer if it's still possible, or it's possible already that for the foreigner who would like to work in Thailand but they do not have the employer in Thailand like a freelance. But the officer told me that it's still impossible because there is no regulation to support on this, so that the officer will not gonna issue the work permit for the foreigner who does not have the employer in Thailand. And the officer also mentioned that even the law, the emergency decree, allow the officer, the authority to issue the work permit, but in reality, when the foreigner apply for the non-immigrant visa with the embassy, the Thai embassy will request for one of the supporting document, which is called the pre-approval letter, or it's called Form WP3. And Form WP3 is the form that the employer, the prospective employer in Thailand must apply for it while the foreigner is outside Thailand. So it's kind of conflict between the authorities. The Department of Employment said yes, we can issue the work permit for you, but in fact the Ministry of Foreign Affairs or the Thai embassy will request document from the employer anyway, because when the foreigner would like to apply for the non-immigrant visa, the employer must apply for the pre-approval letter from the Department of Employment, and also send the package of corporate document from the employer to the foreigner outside country to apply for the non-immigrant visa. So in practice, it's still impossible. And next, I would like to say is about the excluded persons. Excluded persons mean the person can come to work in Thailand without the need to apply for the work permit. What is interesting is the number 6, 7, and 8. 6 is about the persons who come, the foreigner who come to Thailand for the purpose of attending a meeting or arrange the meeting, acting as the speaker. Nowadays, they do not need to apply for the work permit before conducting this kind of purpose. And number 6 is about the persons who has the high knowledge or will be the investor, will be exempted for the work permit. I think this item is revised in March in order to be in line with the smart visa matter, which I will talk about it later. And number 8 is about the representative manager of the foreign entities granted the foreign business license. So in this case, it must be just only the manager level. So other staff of the representative of the foreign entities still need to apply for the work permit. And it must be reminded that the foreign entities must be granted the foreign business license. If that entity is exempted from the license, for example, the regional office or the representative office, the manager still need to apply for the work permit. It's not listed as the excluded persons. Next is about the penalties. The penalties under the emergency decree is quite strict. So there are many complaints on this during this day. So in March, the government issued the revised emergency decree in order to soften the penalties. However, some of those will be in effect as from the 1st of July. So this one that I remarked in the red line, that will be in effect from the 1st of July. So nowadays, we still use the penalty, which is very high. As you could see, the third column is very high, but it will apply just only the end of this month. In main criteria, I would like to say that the foreigner can work provided that they must obtain the work permit beforehand, and they can work and obtain the work permit as long as the applied course is not contradictory to Thai law, And nowadays there are the list of 39 occupations closed for foreigner. So it means that the foreigner, if they would like to work, they cannot work at all because the law does not allow for foreigner to work. And this list of 39 occupations have been used for a long time ago, more than 30 years, and it's still used until now. And this is the list of 39 occupations. I will just show the quick. However, why I put like the green line or orange line? Because I heard the news that some of those will be delisted from the list of 39 occupations. For example, the first one, the worker or maybe accounting. The green and orange will be delisted from the list of occupations. The green will be definitely delisted, but the orange one will be delisted with certain conditions. However, I could not say much about this because the law has not yet been enforced. I heard from the news that it's going to be applied on the 1st of July, but I don't think I'm not sure if it's going to be revised and enforced in the 1st of July because during last weekend I watched the news and I saw that there is some protest from the certain employer who does not agree with the potential revised list. For example, the hairdresser or the window seller, because the employer said they would like this kind of work to be delisted and foreigner can work. But actually, from the revised list to be 28 occupation close to foreigner, they will still include that seller and hairdresser as the occupation close for foreigner. And the employer and some foreigner, which most of them are the Mekong regional foreigners, they do not agree with this because they said that nowadays Thai people don't want to work as the hairdresser or the seller. So one employer said on the television that he tried to find the Thai persons to work as the seller or hairdresser, and he announced like for more than 45 days, but no Thai people come and apply for the post. So, but just only the person from Myanmar. So that's why they said they would like to protest about this to just delist the hairdresser occupation and the seller from the list of occupation close to foreigner. So this is the things that we have to follow up and observe how it's going to be. And in addition to the emergency decree, there is also the notice of the Department of Employment was issued in order to prescribe the details of the work, which is listed as the urgent and necessary work. If the work are regarded as the urgent work, the foreigner does not need to apply for the work permit, but the foreigner must notify the Department of Employment before start working, which normally take like 1 day or less than 1 day, just few hours. And normally the work must be completed within 15 days. If it cannot be complete, can apply for the extension another 15 days. And what is the interesting is number 1, arrangement of meeting, training or seminar, and the second one is the lecturer. I have the chance again to talk to the officer that they are the same work as listed in the excluded persons or not, because I previously said that if any person come to Thailand for the purpose of the meeting, arranging the meeting or acting as the speaker, lecturer. Under the emergency decree, they are listed as the excluded person, so it means that they do not need to apply for the work permit. But in this notice, it listed as the urgent work, which required to notify the registrar before commencement of working. However, I talked to the officer, and the officer said that this item 1 and item 2 was replaced by the revised emergency decree, which was issued in March 2017. So it means that this kind of work will no longer require for the notification and also not require for the work permit. And next is about the notification of the Ministry of Labor. This notification was issued in order to prescribe the exemption for the highly skilled worker, the investor, the executive, startup, business operator who granted the smart visa not to apply for the work permit. However, I think in order to apply for the smart visa, in my opinion, I don't think it's easy because it's limited just only the person who will work for the companies having the qualification as one of the 10 targeted business. If the employers, the companies are listed as one of the 10 targeted business, then the foreigner will be able to apply for the smart visa. And I will talk about the condition and qualification for the persons to apply the smart visa later. But next, I would like to go to the immigration matter. Previously, I talked about the foreign employment, and now I move to the immigration matter. For the updated legislation of the Immigration Act, there is no much change on the Immigration Act. Most of the amendment recently is about amendment in order to be in line with the emergency decree. For example, the foreigner can obtain the visa as long as it will work not contradictory to the emergency decree or the foreign business law. And also they amend about the penalties to the directors of the company if the company is I would like to say that previously, if the company commit an offense, all of the directors will be subject to the same penalties. But according to the amended emergency Immigration Act, the only representative director who is responsible for the performance of the juristic person will be subject to the penalties, same as that subject to the juristic persons. However, as I previously said, there is not much change in the Immigration Act. And next is about the notification of Ministry of Interior and Order of Immigration Office. These legislations are prescribed on prescribed that the persons who would like to apply for the smart visa, if they already get approval from the relevant agency, they have to apply for the smart visa within 60 days from the approval date of qualification. And these two legislations, announcement of Board of Investment Promotion, prescribe about the qualification on conditions for the persons who are able to apply for the smart visa. So this slide and the next slide will show about the conditions and qualification of the persons who are able to apply for the smart visa and the privilege granted to them. For the smart visa, they can be divided into 5 main categories. That is, type T stands for talent or highly skilled worker. Type I stands for investor. Type E stands for executive. Type S stands for startup business operator, and type O stands for other. I start with the type T visa. Type T visa is for the highly skilled workers who are qualified by the relevant agencies in Thailand that he or she is able to work, and the real highly skilled worker for the one of the 10 targeted business. And the company itself must be also certified by the relevant agency on that company is one of the 10 targeted business. And the said persons must obtain the salary not less than 200,000 baht and having the employment agreement not less than 1 year. So if this person can meet the conditions, the privilege granted to this person will be maximum 4 years of visa, and no work permit is required because smart visa already cover the immigration matter and work permit matter. And 1 year notification to the immigration office is required instead of 90 days stay. Next is about the type I visa, stand for investor who invest in the company not less than 20 million baht throughout the period of visa. And the company that he or she invests must be certified of its qualification that it engaged in one of the 10 targeted business. And the privilege granted to the type I visa is the same as type T as mentioned before. Next, type E stands for the executive. Just only the person who will work in the level of executive managing director can apply for type E visa. However, the said person must have the education not less than bachelor degree and also have the experience in the relevant field not less than 10 years. And the company that he works with must be certified of its qualification by the relevant agency in Thailand, also that it engaged in the targeted business. And of course, the right and privilege are the same as type T and type I. Next is the type S visa, stand for the business operator. This is for the persons who has does not need to have the employer, but that person need to have the fixed deposit account in Thailand or abroad with maturity term not less than 1 year and not less than 600,000 baht. A said person must have the health insurance throughout the visa period. And said person must participate in an endorsed incubation accelerator program organized by the relevant agency within the 10 targeted business. And of course, said person must set up the company later on within 1 year from the approval of visa. The said person must invest in the company not less than 25% of the registered capital and or act as the director of the company. And said company must again be certified of its qualification that it engaged in the 10 targeted business. And the privilege of the person who granted the type S visa is similar to type T, I-E. However, just only period of the visa granted are different. That is, this person will get only 1 year for the first year and 2 years in the following years. So and type O stand for other or accompanied persons. Accompanied person will enjoy the benefit about staying and working without a work permit if they are above 18 years. And this shown in the slide is the abbreviation of the relevant agency that are able to certify the qualification of the foreigners and the companies on the 10 targeted business. The process. In order to apply for the Smart Visa, the foreigner must apply for the qualification of himself, and once it's approved, then the foreigner can attend the embassy in order to get the visa stamp in the passport. And for the procedure to apply for the qualification, the foreigner must submit the required document to the embassy if he or she is in outside country, and submit to the one-stop service center Smart Visa unit if the said person lives in Thailand. And then I will call it one-stop service center. Once the one-stop service center receives the documents from the foreigner or from the ministry, from the Thai embassy, the one-stop service center will pass the application to the relevant agencies to qualify the qualification, and also pass the matter to the other authority, which is the Ministry of Foreign Affairs, to check the background of that person, and to the Immigration Office to check the blacklist, and also to pass the matter to the Department of Employment to check if the applied post is prohibited under Thai law or not. And these authorities, these agencies will take time about 20 business days and give the feedback to one-stop service center. The one-stop service center, once receive the feedback from them, will just review the matters for 7 business days and then give the result to the foreigner, and also for the to the authorities that already considered the matters also. So in total, about the process to apply for the qualification, it will be 30 business days. And it said that qualification approval for foreigner. In this, the authority will also certify the qualification of the company that the foreigner will work with also. And once the approval is granted to foreigner, the foreigner must contact the Thai embassy if he resides out, he's in abroad, or one-stop service center if he resides in Thailand, for endorsement of the Smart Visa in the passport, or change of the visa, change of the non-immigrant visa to Smart Visa, and endorsement of Smart Visa there in the passport. And this slide show about how to renew the Smart Visa. Normally they said it's prescribed that the foreigner who would like to apply for the Smart Visa or renew the Smart Visa, they must do it 90 days before the expiration of the current visa. So it means that if the foreigner who already have the non-immigrant visa at this moment and would like to apply for the Smart Visa, they can apply for it if there is the remaining period of visa more than 90 days. Well, before I talk about the Smart Visa, and now I will come back to the general work permit and visa. Although the legislations on the foreign employment are amended, however, for the conditions to apply for the visa and work permit and remain the same as before. That is, the foreigner who will apply for the work permit must grant the non-immigrant visa, and the foreigner must earn the income not less than specified in the regulation, and the hiring company must have the registered capital with fully paid up not less than 2 million baht, and it will be 3 million baht in case it is the foreign entity granted the foreign business license. And the next conditions is about the ratio between Thai and foreigner, which must be maintained not to be less than 4 Thai employees per 1 expat. However, the said ratio 4 per 1 will be decreased to 1 per 1 in case of the representative office, regional office, or branch office. And there is no restriction of Thai employee per expat employee at all in case of the employer company granted the investment promotion by the BOI or established the business operation in the IEAT, Industrial Estate Authority of Thailand. In general, the officer of the Department of Employment will grant the work permit just only 10 work permit. But if some company would like to apply for additional work permit, the employer must satisfy one of these conditions, which is the company had paid income tax in the recent year not less than 3 million baht. In case the company engaged in business of import-export and bring in the foreign currency, it must bring in foreign currency not less than 30 million baht. Or in case the company engaged in the tourism business, the company must bring in foreign tourists not less than 5,000 baht. And or the company has employed more than 100 Thai workers, Thai employees. So it is possible for the company to apply for additional work permit. However, this is the description of the foreigner, but for my experience, if the hiring company can satisfy one of those conditions, the additional work permit will be granted. And this is for the work permit issue, but for the long-term visa, of course, the hiring company still need to comply with the general rule that is about the maintain at least 4 Thai per 1 expat, and the foreign employee must have the salary not less than that specified in the regulation, and the officer will also consider the company's balance sheet, that the company must have the income not less than the total salary and benefit paid to all employees of the company. So if they could certify all of this, the long-term visa will be granted to additional foreigners. Well, the process to apply for the work permit and visa still the same, but just only something changed about the time. So I just talk about the scenario first. Scenario 1 first. If the foreigner would like to come and work in Thailand, if they check the website of the Thai embassy, if one of the required document is the pre-approval letter or it's called the BOP3 form, it means that the foreigner must contact the prospective employer in Thailand to apply for the pre-approval letter with the Department of Employment. It will take about 7 business days for the DOE to issue the WP3 letter. Once the letter is granted, the prospective employer must send said letter together with the package set of the corporate documents to the foreigner outside Thailand, so that the foreigner have the documents, the full set of documents to apply for the non-immigrant visa. Then when the foreigner obtain the visa, he can come to Thailand, arrive Thailand, the immigration office will stamp 90 days stay, and then the said person must go to the hospital for medical checkup and then submit the application for the work permit. In the past, the foreigner must submit the application for work permit within 30 days, 30 from the pre-approval from the date specified in the pre-approval letter, the WPT form. But nowadays, 30 days start counting from the date entering into Thailand. This was I discussed with the officer in April. He said that okay, the time just internally changed about because so that the foreigner have time after receiving the visa, have time to pack the bag and come to Thailand, have time to relax before applying for the work permit. And if the visa granted for the foreigners is short term, 3 months, the foreigner must apply for the long term visa so that they can stay longer. But however, in order to apply for the long term visa, the foreigner will be able to apply for it just only 30 days before the expiration of the visa in case of the immigration office. But if the foreigner will apply with the one-stop service center, it will be 45 days before expiration of the visa. And of course, the foreigner is required to apply for the re-entry permit so that the foreigner can go in and out with unlimited time. And each stay, when the foreigner stay in Thailand for a long time, the foreigner must be reminded to notify the stay to the immigration each 90 days consecutively. The scenario 3 is about if the Thai embassy does not require the WP3 form, so the foreigner just only contact the prospective employer in order to send the package of the corporate documents. No need to wait for the approval letter from the DOE. So when the foreigner receives the set of corporate documents from the prospective employer in Thailand, he or she can apply for the visa and come to Thailand and then go to the hospital and apply for the work permit. There is no time constraint for this scenario, but the foreigner must apply for the work permit before the expiration of the visa. And in order to apply for the long-term visa and re-entry permit, it is the same as scenario 1 or 2 as said before. Next is about the process to apply for the work permit and visa under the BOI system. This is in case the hiring company are granted the investment promotion or BOI. The process to apply for the work permit and visa under the BOI system are different from the general process. To apply the visa and work permit under the BOI system, we call e-expert system, so we can do it by online. And there are the steps that the employer must first apply for the position to be for the foreigner to work in that position. So it means that the company must have the organization chart to show that what the positions that the company need to hire foreigner to fill in the said position. And once the position is approved, the employer must request the BOI to issue the letter requesting the Thai embassy to issue the non-immigrant visa for the foreigner. Then the foreigner can apply. Of course, the foreigner must can apply for the visa outside Thailand. Then the foreigner come to Thailand, and then the employer must apply apply for the bringing in the foreigner into the approved position. And once that application is approved, the foreigner the employer must schedule the appointment date before, and then the foreigner can go and receive the work permit and maybe apply for the long-term visa and re-entry permit if the time allows when they go and obtain for the work permit. And of course, the notification of 90 days stay also required. So in this slide, I would like to show the comparison between the general work permit and visa and smart visa. First of all, it's about the person who can apply for the general work permit and visa. Under the current law, emergency decree is any person who would like to work in Thailand. But in practice, said person must have the prospective employer in Thailand so that they are able to work in practice. And for the smart visa, it's limited just only to the highly skilled expert, investor, executive, business operator, startup, who will work for the 10 targeted business and obtain the smart visa. And the period of visa and work permit. In general, work permit and visa, it can be maximum 2 years, but in practice it's like 1 year. And for the smart visa, the period of visa is 4 years maximum, but for the type S visa, it startup. It's just only 1 year for the first year and 2 years for the following years. And for the notification to the immigration for the general work permit and visa is 90 days stay consecutively. But in case of the smart visa, it will be 1 year instead. And for the renewal of visa and work permit, in case of the general work permit and visa, can be anytime, but before the expiration of the visa, which I do not recommend because maybe it's too close to deadline. You should give time a bit to apply for the work permit and visa because you never know what's going to happen at the Department of Employment and Immigration Office because there are so many descriptions there. And about the smart visa, it must be renewed not less than 90 days before the expiration of the visa. We'll come to an end of the termination of the employment. When the foreigner would like to terminate the employment, the employer must cancel the visa on the same and leave the country on the same date of termination. However, I know that it may be so too close and maybe you don't have time to prepare things. So it is possible for the foreigner to just notify the immigration in order to cancel the visa before, but it must be within 21 days before the expiration, before the termination of employment. And also, the foreigner may be able to apply for the renewal of the visa, but must be before or on the termination of employment. And for the employer must notify the Department of Employment on the cancellation of the work permit within 15 days from the date of termination. Otherwise, the employer will be subject to a fine. Well, in addition to the work permit, visa and smart visa, that is the interesting things that I would like to talk today. It's about digital work permit. I know that the foreigners are suffering from carrying the blue book many times, and because for maybe you need to have like the smartphone, wallet, the passport, so too many things to carry. So if you are able to apply for the digital work permit, it's good. It's just only good, But in order to apply for the digital work permit, it's not easy because it's limited just only for the persons, for the foreigner who will work for the company granted the business, the investment promotion, and only the company using the system which is called single window system will be able to apply for digital work permit for the foreigner. However, in order to be able to use the one single system, did I say correctly or not? Single window system, yeah. Single window system. In order to use that, the company must send the staff member to participate in the training workshop. And the training workshop will be open once a month with limited seat, only 50 companies per month, and the one company can send 2 member staff. So it means that just only 100 people and 50 company can participate in the training workshop, so that company are able to use the single window system. I talked to the persons who is responsible for the matter about the digital work permit and asked if how it is now, because I don't hear much about this. I just know the news last year, and they said that now it's closed. It's closed for improvement the system. And that nowadays there are just only 200 companies being able to use the single window system, but nowadays it's still closed and just only 200. So they said that maybe we have to follow up the news, and maybe possible to open the training session in August, but it's not confirmed. It is your duty to follow up on this matter if the training workshop will be started or not. And the process to apply for the work permit under the Windows single system actually is the same as the e-expert system, but when enrolling the name of the foreigner into the system, it will be enrolling in the separate single window system. And when the employer already apply for the approved position, bringing in the foreigner into the approved position by enrolling it in the single window system,